Welcome to Spiedel's California Minute. I'm your host, Catherine Zidane. This week, we're talking about changes that Proposition 19 made to transfers of California real property between parents and children. For a deep dive into California property tax issues, sign up for Spiedel's Property Tax Transfers webinar on September 5th. You can see a full list of topics covered and get registered at caltax.com under webinars. Passage of Proposition 19 may result in an increase in property taxes for transfers of California real property between parents and children or vice versa than would have occurred under pre-Proposition 19 law. The same rules apply between grandparents and grandchildren as long as the parents of the grandchild are deceased at the time of the transfer. Under prior law, there were two exceptions from reassessment that applied for transfers between parents and children. The principal residence exclusion, which allowed the transfer of a principal residence of unlimited value between parents and children, and the $1 million lifetime non-principal residence exclusion, which allowed the transfer between parents and children of up to $1 million of assessed value of all other types of property, for example, second homes or rental properties. For a married couple, this would be a combined $2 million lifetime exclusion. Under Proposition 19, for transfers on or after February 16, 2021, in order to qualify for the principal residence exclusion, the receiving child is required to use the residence as their own principal residence within 1 year of the transfer, and only the first $1 million, adjusted for inflation, of additional assessed value is excluded. For transfers occurring February 16, 2023 through February 15, 2025, the exclusion is equal to $1,022,600. Also, the non-principal residence exclusion has been completely eliminated. However, the principal residence exclusion will apply to transfers of family farms, even if there is no principal residence located on the farm. There are no limits on the number of qualified transfers a transferor makes. So if a parent resides in one home and transfers that to one of their children and then moves into another home and lives in that home for a number of years, the parent can transfer that home to another child. In this scenario, both children would be able to claim the exclusion as long as they live in the home that was transferred to them. A qualifying principal residence includes property owned by a decedent's estate, whether directly or through a trust, if it was the decedent's principal residence immediately prior to their death. It does not apply to principal residences held in an entity or irrevocable trust, including limited liability companies. A principal residence also includes any accessory dwelling unit or junior accessory dwelling unit located on the parcel transferred. If the child moves out for more than a temporary absence and rents out the home, the property no longer qualifies for the exclusion. The base year value of the property will be set at the fair market value of the property when the property was inherited, adjusted for inflation for each year the child owned the property as their family home. If one child moves out and another qualifying child moves in, the exclusion will remain in effect. Both children must have been named in the transfer for the exclusion to remain in effect. If a parent left the house to one child and stocked to another child, then the exclusion will only apply if the child to whom the house was left resides in the home. To preserve flexibility in terms of the exclusion, parents should consider leaving the house to all of their children. Spiedel's California Tax Letter is a monthly newsletter that will ensure both you and your clients are up to date with California tax law changes. You can get subscription details and download a sample issue at caltax.com under Publications. That's all for this week. Join us next time for another episode of Spiedel's California Minute.